I think a positive result is only the process going fairly, because I don't think a positive result can be asking for a finding of guilt or finding that the allegations were true. One can't ask that because one doesn't have all the evidence before one, right? But when it was constituted, despite its sort of history of lurching from one place to the other, I did think at the point that Justice Ramana recused himself and Justice Malhotra came in his stead, that this was a process that could be strengthened and could be fair. By strengthening, I mean that at that point, if an external member had been added and if it had been clear that either Justice Malhotra or Justice Banerjee, both of whom are women, had headed the committee, the panel, and if there had also been an external member, either Justice Ruma Pal or even a woman of eminence who understands legal procedure like Usha Ramanathan or Aruna Roy, somebody of unimpeachable integrity, then it could have been a fair process. It could have been perceived to have been a fair process, and I think that's what would have made it a much fairer process. But since then, the way things have gone have been somewhat unfortunate. For example, in any other such inquiry, the complainant would have the assistance of a colleague to assist her. And this is something that was denied. And I can't see why she would not be allowed a lawyer, given the fact that the balance of power was so massive here between a court, particularly in the area of law, between a court assistant and the Chief Justice of India, that I think that a lawyer on a amicus curiae is something that really should have been granted in the blink of an eyelid. It says that you're not allowed to have outside counsel, but you're allowed to have assistance. You are allowed to have assistance from within the government department or from within your workplace. So that you are allowed. And that is something reportedly that she did not get. So they did not even comply with the basic, whereas of course they should have gone far beyond, given the particular circumstance. There is no reason that a writ before the Delhi High Court would not be maintainable under Article 226. Given, for example, the RTI decision, by which on the administrative side, the Supreme Court had decided that they were not amenable to RTI jurisdiction, right? Whereas then Justice Ravindra Bhatt, I think, had decided that they were amenable to RTI jurisdiction, which is, at any given point, that was a courageous decision. And this would take a judge that had courage and integrity above and beyond what any judge has ever been called on to do, because what he or she would be required to do is to seriously jeopardize their chances of elevation to the Supreme Court. And this is why some people become High Court judges at all, right? Secondly, face possibilities of backlash in other ways. And thirdly, just separate themselves from their sort of otherwise empathy and loyalty to their brother judges. If you look at the consolidated decisions of the High Courts, examining decisions of ICCs, then there are a number of principles that emerge. And they really are, I'm just citing decisions of the High Courts, right? One, that reasons must be given. Right? So at the first instance, the decision can be challenged, and the decision exonerating CJI can be challenged, then saying that reasons were not given. And on that basis, if the report is called for, then it could be amended and the report be impugned. Right? The second is that if the complainant withdrew, where is the natural justice? Obviously, there were a number of issues that she would not be able to speak to because she wasn't there. Thirdly, the natural justice, the content of natural justice varies according to the nature of the hearing, and where the nature of the hearing is that you are impugning the actions of a Supreme Court Chief Justice before a Supreme Court panel, then surely natural justice requires that you be assisted by a lawyer. Now, even if you do not flesh out natural justice to that level, at the very least as a flaw, you have to follow the principle, what every other workplace follows. Why would you not give her the assistance of a co-worker to support her in the hearing? As anyone who has been through anything like this will know, that you cannot, it's upsetting to be in a victim's position. It's very difficult to marshal your case and argue your case if you're in a victim's position. Obviously, you need help. So, I don't think natural justice was followed here. I certainly don't think it was too late to provide her with assistance at all. I mean, if she had asked for assistance and she was willing to sort of stay before that committee and she was going to participate, then of course she should have been given assistance. I don't think it was too late at all. Mm-hmm. Was it too late to add an external member? Well, I mean, the court had done a good thing by evolving its process after the many missteps that it did make. I think that's a good thing, and I think mistakes are made, but if you end up in the right place, then it's okay. And if at that point they had then added an external member after hearing her and heard her afresh, I think that would have been better. But all of this is to really say that a structure that was robust and that was fair and that had proper due process with sort of strong natural justice is what would give the space to have a fair hearing and exonerate, honorably the Chief Justice, from these allegations, had that been the call of the panel looking in complete fairness into the case. This way, the entire process has been so unfair, actually, that where is the space? That obviously the final decision appears to be, completely, the final decision maligns the sort of reputation of fairness of the court, because of the process that is so problematic. And so I just think that the court has really not done itself any service at all in this regard. I'm not a soothsayer when it comes to protests. I have no idea what's going to happen with these protests. But there are ancillary proceedings that seem to be springing up out of all of this. For example, there appears to be a petition by a lawyer who has been fined repeatedly by the court in the past for bringing frivolous litigation. And apparently it seems to bring into say that there's a criminal investigation required of 4 prominent human rights lawyers, some of them senior counsel. And the investigation is required because apparently, and what is alleged against them is that they were advising the complainant. Now, I mean, surely a complainant, however unpopular, is deserving of legal advice. And surely there's attorney-client privilege that should not be breached. It's unclear to me why, in such a petition from such a litigant, court time would be spent on that. Also, that if you look at the Utsav Ben's affidavit, again, it spoke of some very serious things and very serious allegations. But if you look at the lack of consistency, for example, his Facebook post said that it was a conspiracy by one set of people. Then he says, then he has an affidavit which says it's employees. Then you said it is brother judges. Then you have another affidavit which says something else. So the whole thing has really been unfortunate. I do think that should the inquiry report be given to the complainant, and should a writ petition go into this very swiftly, really very swiftly, because it is the Chief Justice we are talking about, sitting day to day, I think. I don't know, maybe that's the way forward, but frankly, it's a matter of sadness that things have come to this pass.